Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning, everyone. We're here today on S-1-SC-38937, State versus Ayon. May I have entries of appearance, please?
There's Scott Davidson for amicus curiae, Investor Crew Defense Lawyers Association.
Jameson Barkley, also here on behalf of NCDLA. Meryl Franklini on behalf of the state.
All right, Ms. Smith, it appears that you have reserved 13 minutes for your argument in chief, and you have ceded 10 minutes of your time to amicus. Is that correct?
That's correct.
And that you have then likewise reserved 7 minutes for your rebuttal.
Yes, sir.
All right, you can proceed.
May it please the court. The question presented today is whether a court that conducts a preliminary hearing may exclude illegally obtained evidence from its determination of probable cause. The Court of Appeals held that a court does not have this authority. Instead, the court is prohibited from enforcing the defendant's Fourth Amendment and Article 2, Section 10 rights at the preliminary hearing stage. This is inconsistent with the role that the judge plays at preliminary hearing. It is inconsistent with New Mexico's strong protections against illegal searches and seizures, and it undermines the screening function of the preliminary hearing. Mr. Ayon is asking this court to reverse the Court of Appeals and hold that a court conducting a preliminary hearing may exclude illegally obtained evidence from the probable cause determination. I should note before I go further, Mr. Davidson will primarily be addressing Article 2, Section 10. I will primarily be addressing other issues. I want to start with one aspect of the Court of Appeals opinion, which is it relies pretty heavily on the fact that Rule 5302 doesn't explicitly authorize exclusion. The Court of Appeals says this is a plain language approach. There's nothing in the language of the rule authorizing this, therefore it's not authorized. But the committee commentary to the rule actually says not to read the rule that way. It says that the list of procedures and rights in the rule is not intended to be a comprehensive list of the defendant's rights at preliminary hearing, which suggests that we should not read the rule's silence on that point as stripping defendants of rights. This focus on the plain language of the rule also comes at the expense of the constitutional concerns in the case. So the court assumes there needs to be explicit authorization in the rules for a court to enforce the Constitution, or else the constitutional protections don't apply at that stage. That seems backwards. Generally speaking, judges do not need permission to enforce the Constitution. And there's also the canon of constitutional avoidance. This court has said that it avoids interpretations of statutes and therefore also rules, not only that would be unconstitutional, but that would raise grave constitutional doubts. A reading of the rule that would strip defendants of rights under the Fourth Amendment and Article 2, Section 10 at the preliminary hearing would tend to raise those constitutional doubts. We would tend to avoid that reading of the rule. And there's a very real difference for defendants between having their rights against illegal search and seizure vindicated at the preliminary hearing stage versus at a suppression hearing months or maybe years later. So during that time, the person is being prosecuted. Prosecution entails, the case law talks a lot about this, anxiety, humiliation, and concrete restrictions on the person's liberty, which may include pretrial detention, but assuming it doesn't, could include regular drug testing, could include having to get permission to leave the county, could include not being able to go certain places.
How do we address the idea that someone who is forced to go through a grand jury proceeding would not have this right under any circumstances, whereas someone who is a preliminary hearing is required in their case would have those opportunities? How do we resolve that difference?
Sure. The answer is just that grand juries and preliminary hearings are completely different. That this would be one of many disparities in how people are treated at grand jury versus at preliminary hearing. it's, when you look at the rights afforded to a defendant at preliminary hearing versus the rights afforded to a target of a grand jury, a preliminary hearing is an adversarial process. There's a right to counsel. There's a judge making rulings. The rules of evidence apply. The defendant may cross-examine witnesses. The defendant may bring in witnesses. None of that is going to be true at grand jury. So they're just very different.
They're different procedurally,
They're very different procedures.
but the substantive decision to be made is whether there's probable cause.
Right. So
Oh.
right. So that the purpose is the same, but the function and procedure are very different.
But so effectively though, what happens is if a case is a grand jury case, you're out of luck, you don't get to assert your constitutional rights at the early stage. If you're a preliminary injunction, woohoo, good for you, you get to assert them then.
Basically, yes, Your Honor. And that's,
Why should we condone that
I mean, this is
or
what led
adopt that?
this is what led the California Supreme Court to say there's a constitutional right to a preliminary hearing. They're just different. A grand jury is not part of a prosecution. It's an investigative body. It's an investigatory body. And the idea of a grand jury is that there aren't the same level of legal protections that you get at a preliminary hearing, but the prosecution will be in some way restrained by having to present the case to a jury of the person's peers. You could see a grand jury being, even if a grand jury doesn't know how to apply the exclusionary rule, the idea is that a grand jury could say, we're appalled by the state's behavior in some case, and therefore we're not going to find probable cause either. But there's a really big disparity.
But a judge could do the same thing, weighing the evidence.
Right, we don't expect judges to nullify, but yes, a judge could make a
But
ruling.
let me ask you this, what would be the binding effect of a finding that evidence was or was not obtained in violation of the Fourth Amendment? Is it then binding on all future proceedings?
It is not. It is, I think Hardy, which is a corpus delicti case, says that there's a provisional question of admissibility, which is a nice phrase in an otherwise somewhat confusing opinion. All of the determinations.
So it's a provisional, if it's provisional
Yes,
to the admission of evidence, it's not a constitutional right that's being vindicated. It's a finding that it's a provisional foundation to the admission of evidence.
well, it's a
So
provisional.
what am I missing?
It's a provisional determination that the evidence was or was not constitutionally obtained. It's
What's
not.
provisional about that? I'm sorry.
It's just-
Either it is or it isn't. What do you mean what's provisional about that?
It's just that it doesn't bind the future court. It's not that it's not that the judge sitting at preliminary hearing says, well, I don't really think this is true one way or the other. That person makes a determination, but then like the other determinations at preliminary hearing, other than the ultimate finding of probable cause, it does not have preclusive effect later in the case.
So when the trial court finds constitutional, strike that, when the judge hearing the preliminary hearing finds constitutional violation, throws out the charge, DA goes to grand jury, defendant gets indicted, then you're in front of the trial court judge. The judge is bound by that holding that it's unconstitutional.
Correct. And we would hope that if the judge the first time at prelim was correct, that there's going to be the same result, but the judge is in no way bound and might not even know about that earlier ruling. Usually the preliminary court records aren't exactly part of the
What is
trial court record.
provisional about that? Are there facts that change?
So I think the idea is that in a preliminary hearing, everything is happening pretty quickly, and you might not have the level of factual development you would have later. You don't want to have those determinations be binding, but you do want to have the court make them, just like you'd have the court make an evidentiary determination to say, no, this statement is privileged, that can't come in at preliminary hearing. That doesn't mean the trial court later has to treat that same statement as privileged. There's no collateral estoppel there. It's
Why not? Same
It's a-
issue, same parties?
it's a good question. It's just never been applied that way.
Aren't you setting up the trial court in an untenable situation where a judge handling the preliminary hearing may make certain credibility determinations about the witness and then make a decision, and then perhaps the case gets bound over. Another judge is asked to suppress for trial and makes different credibility determinations. How do you resolve that within one case?
It's just inherent in the nature of preliminary hearings. And it's part of why really the preliminary hearing, I'm not quoting the law here, I'm just saying in my experience, it's part of why you don't have the preliminary hearing as part of the record. It's something that happens, you have a determination of probable cause, and then the case moves on and starts over as a felony trial case.
So
Wouldn't that suggest that, in fact, the exclusionary rule should not attach at the preliminary hearing phase?
Well, no, Your Honor, because part of the point of the preliminary hearing, the real point of the preliminary hearing is to serve a screening function. The state talks a lot in its briefing about the purpose of finding probable cause. But if the state doesn't.
Can I interrupt for a
Yes.
moment, please? I recall that in the state constitution, it says a district judge cannot overrule another district judge, a co-equal judge. How does that play into this?
Your Honor, it's not a matter of overruling. It's a matter of you, at a later point in the case, the state may be presenting different evidence at a suppression hearing. You could see things going a different way. But we would hope it would generally go the same way. It's not being considered in an appellate capacity. I do want to point out the flip side. If you cannot exclude inadmissible evidence at the preliminary hearing, what that means is we're forcing judges, for one thing, to condone a constitutional violation that is apparent to them. And for another thing, we're forcing the judge to bind over a case that may be unsupported by admissible evidence, which really does undermine this screening.
And that's kind of my thought of it, and this will be the question I'm asking Ms. Francolini, but if the only evidence supporting finding probable cause is something that is overtly unconstitutional, you're requiring the judge then to find probable cause based on something that is overtly unconstitutional. That seems upside down to me. I know you're going to agree with me on that statement, but.
Couldn't a judge say that this appears to be overly unconstitutional, so I give it no credibility?
Yes, Your Honor. And
Okay.
in most cases, that's what's going to happen because probable cause is a pretty low bar. So mostly the state is going to have a bunch of evidence and the defendant might say, well, this was unconstitutionally seized. And the judge might say, I don't even have to reach that. I can assume that that was unconstitutionally seized and there's still probable cause based on this other testimony or this other statement.
The other procedural issue here is arguably the state had a right to appeal because it was a district court preliminary hearing. But if it's a preliminary hearing by a magistrate judge, where would you have a right to appeal?
So, Your Honor, there are going to be a lot of options for the state if this happens in
And the
any
defendant?
court. One option is going to be, if the state should do some soul searching and see if it thinks the judge was right. Because if the judge is right and there is no admissible evidence to support the charge, it doesn't make sense to circumvent that ruling. But beyond that, the state can always re-present at a preliminary hearing with additional evidence or with additional argument. I don't see a reason they couldn't refile and say, we're including a brief this time of the law that we think means you got it wrong. We want to re-argue this. And I believe in the new rules that come into effect next month, is it? If you have a preliminary hearing in magistrate court, you can refile in district court for a second preliminary hearing. If I may I add one more thing?
You may.
I don't know the details of appellate procedure out of a magistrate court non-bind-over determination, but whatever you would normally do to appeal, you could do as well.
Thank you.
Thank you, I'll be back.
May it please the court. My name is Scott Davidson. I'm representing the New Mexico Criminal Defense Lawyers Association as amicus curiae in this case. The focus of my argument is on the constitutional dimension of the question presented. Without so much as a citation to Gutierrez, the Court of Appeals opinion in effect constitutes a sub silentio repudiation of Gutierrez and this court's jurisprudence around Article 2, Section 10, and New Mexico's exclusionary rule. The effect of the Court of Appeals' published opinion is to require a district court to use illegally obtained evidence in making probable cause determinations, even if it is clear that the evidence is tainted by an unreasonable search and seizure in violation of Article 2, Section 10. But requiring the courts to rubber stamp a prosecution that is so tainted and rely on illegally obtained evidence denigrates the Constitution and this court's opinion of Gutierrez. The Court of Appeals and the state in their briefing frame the question as being whether Rule 5302 specifically authorizes the district court to exclude illegally obtained evidence. And then they proceed to apply standards of statutory construction. But this approach fails to take into account the constitutional dimension. Their approach is flawed because, in effect, it creates a free fire zone where the state can violate fundamental rights in obtaining evidence and then use that to support a probable cause finding that the defendant committed a felony in a criminal proceeding in the courts in New Mexico. Now, there's been discussion about the narrowness of the purpose of a preliminary hearing. And that narrowness does not place such proceedings beyond the reach of the Constitution. A finding of probable cause is necessarily based on evidence obtained by law enforcement and presented by the state. And Rule 5302 is replete with references to examination and evidence, underscoring the fact that in these hearings, a neutral judicial arbiter determines whether the evidence presented by the state meets the probable cause threshold that a crime was committed and that the defendant is the person who committed the crime. So, to underscore the differences, going to Justice Vargas's question about grand jury versus preliminary hearing, underscoring what Ms. Smith was saying, the preliminary hearing is an adversarial setting, whereas a grand jury is not. It's a public proceeding, whereas a grand jury is secret. It's governed by the rules of evidence, whereas a grand jury is not. The defendant has already been accused of a felony in a preliminary hearing, whereas in a grand jury, it's an investigation and that person is a target. So it's an important stage in a criminal proceeding at which the defendant also has the right to counsel, cross-examine, and even to produce.
Can I ask you a practical type of question, since you're here on behalf of the defense lawyers? If we go down the path you urge us to, aren't we going to, isn't the consequence of that is that prosecutors are going to run to grand jury and disavow preliminary hearings? Because it's so much easier, as we know, to navigate a grand jury. So we have this constant debate in certain districts in New Mexico, certainly in Judge Lovelace's district, that we need more grand jury, we need more grand jury. And isn't that din going to become louder if we go the direction you want us to? And doesn't that ultimately undercut the goals of your client?
Well, it's always a prosecutorial decision whether to do a criminal information and then preliminary hearing versus grand jury. And there's a lot of practical considerations that the law leaves to prosecutors to sort out. And having never been a prosecutor, I can't educate the court about what those considerations are. I am aware of the differences that Your Honor just pointed out. And there may be implications like that. But for instance, when this court looked at in Cardenas-Alvarez, the question there was whether a stop at a federal border patrol checkpoint, where the evidence that was seized there in violation of the state constitution could then be admitted in state court when it was originally seized by federal agents. And one of the arguments was, this is just going to make the federal authorities skip referring these cases to state courts and go to federal courts. And that might be to the detriment of those clients in those sorts of situations. And there may be these sorts of implications, practically speaking, over the course of a population of cases. But when this court is sitting in judgment on the Constitution and how the Constitution applies and what the district court's authority is, I think that those practical considerations, although you can be aware of them and not blind to them, I don't think that they override the constitutional concerns, particularly when you look at Gutierrez. Now, Gutierrez, it's been pointed out by the state that the procedural posture there was a suppression of evidence related to evidence that was going to come in at trial, whereas in this case, in Ayon's case, it's at a preliminary hearing. But if you look at how the Gutierrez court described the issue, the court said the issue was the constitutionality of the admission of evidence seized in violation of Article 2, Section 10 in a criminal action founded on illegal government conduct. It didn't say at trial. Also, in paragraph 54 of Gutierrez, the court underscored that what the exclusionary rule in New Mexico does is it returns the parties to where they stood before the right was violated. Applying that in this case, going back to the status quo ante, you treat the evidence seized by Officer Lyman from Mr. Ayon in violation of the Constitution as if it was never obtained. So that's how you restore.
But that's not binding on the district court later on,
Correct.
according to the position we're hearing. So it's some kind of a preliminary assessment of that evidence to come to a preliminary conclusion that it violated some provision of the Constitution, but it's not binding. And on the other hand, and answer me this, why couldn't the magistrate judge or the district judge sitting in preliminary hearing make an assessment? I believe this kind of evidence was obtained unconstitutionally, and therefore I'm not going to consider it, without making a finding that it violated the Constitution.
But I think the Court of Appeals opinion prevents the court from doing just what you're contemplating. It says the court is required to consider that evidence regardless of how blatant the constitutional violation is. And also there's the fact that in this case, none of the evidence that the state presented was outside of the ban on, another better way to put it. So all of the evidence was obtained illegally. You can imagine a case where some evidence was obtained legitimately and some illegally. That's a different case. And the judge would then have to subtract the evidence, much as a judge does in a suppression hearing, subtract the evidence as illegally obtained, and then see if there's enough probable cause based on the evidence that is left over. Similar to, as Your Honor was suggesting, a credibility finding. I find this witness uncredible. I'm not going to rely on that. I'm just going to rely on the evidence I find credible and tenable.
So the trial court declares that this search and seizure of the opioids was unconstitutional, finds no probable cause. Count 1 of possession, it's out. Can the state appeal? What is the standard of review?
The standard of review, this is
On
a
both?
district court
On both?
appealing to the Court of Appeals, I guess in this case.
The state losing a probable cause determination.
Right.
Appeals, can they appeal? And what is the Court of Appeals standard of review? On the question, the constitutional question, and then the lack of probable cause.
Well, in this instance, if it's a final order, a final appealable order, then yes, they could appeal.
Okay.
For secure, because the case is dismissed.
What's the standard of review on a provisional decision of a constitutional violation?
Well, I'm not sure that I would characterize as provisional. I would say that it has to do with that hearing, but the standard
I just
review.
heard it was provisional.
Well, I guess what I would say is that in a suppression hearing under Rule 5-212, the whole point of that hearing is to look forward to a trial and say, can the state bring in this evidence in their case in chief? In a preliminary hearing, the state is putting on evidence and saying this meets probable cause that a crime was committed and this person is the one who committed it. So on appeal from a dismissal, as in this case, then the standard review would be similar to what this court said in Attaway, that the findings of fact by the district court are going to be reviewed under a deferential sufficiency of the evidence standard.
On a constitutional question.
But it's a bifurcated standard under Attaway. So it's de novo is the constitutional. That I would think it would be de novo is the constitution. If the court has no further questions. Thank you.
May it please the court. Preliminary hearings serve a limited purpose, and that purpose is only to determine whether probable cause exists to proceed with prosecution. That limited purpose does not encompass review of the legality of evidence, and nothing in Rule 5302 or elsewhere in New Mexico law contemplates including suppression hearings within preliminary hearings.
What about the argument that I talked about and that was also discussed by opposing counsel? You are requiring this, the Court of Appeals opinion requires a judge to entertain obviously illegally seized evidence. Therefore, the judge is participating in the Fourth Amendment violation, arguably. That seems contrary to the role of somebody that we have imbued with the authority to separate, the wheat from the chaff. And I think the end result of the way this opinion is written is it could be the stinkiest, ugliest seizure you've ever seen. I mean, we can come up with some parade of horribles. And guess what? You're going to rely on it, ignoring all of its warts for your probable cause determination.
And I agree with Your Honor that that is probably the most pressing concern that comes out of the Court of Appeals opinion. A couple things. I think the number of cases in which that would be the case, that it was this constitutional violation that was so unbelievably clear on its face to everyone or to the judge, and all of the evidence was illegally obtained. I think the number of those cases where kind of the stars would align for those circumstances to be true would be very low by comparison.
That may be true, but we're talking about the Fourth Amendment. We're talking about a constitutional right that we carry on our backs everywhere we go. Unlike many constitutional rights, which are triggered once action is taken, this is something that we are imbued with in our everyday lives. It's a pretty significant consequence. So to say that, well, it's only going to be a problem for a couple of people, I'm not sure carries the day because of the import of the right, at least in our jurisprudence.
I think a district court or a preliminary hearing judge always has the option to make a finding of no probable cause, and I suspect that if the Court of Appeals opinion stands as it is, and
They're just going to silently do it.
they might.
And
They
is that,
can
but
do
is that legitimate either to force Judge Lovelace, I'm picking on Judge Lovelace a lot today, to just say, no probable cause, and then you don't know what the infirmity is for purposes, the prosecution doesn't know what the infirmity is for purposes of cure, deciding they want another preliminary hearing, going to grand jury, whatever the case might be.
Right, it's certainly not ideal.
And I don't think we encourage judges as a general rule to silently make decisions because the Supreme Court has announced a rule that is odious to the process of a probable cause hearing.
I agree, Your Honor, I completely agree.
We typically don't do that.
So what I would say, how I would respond to all of this in general is that both federal law and New Mexico law treat the exclusionary rule as something that kicks in at trial. And that's not to say that every New Mexican doesn't have the right to be free from unreasonable searches and seizures. We all do. But what this court said in Gutierrez, which is a case that the defense has relied on very heavily, Mr. Davidson cited paragraph 54. If the court moves on to paragraph 55, which is one of the concluding paragraphs, it all comes together in that opinion. And this court said, denying the government the fruits of unconstitutional conduct at trial best effectuates the constitutional prescription of unreasonable searches and seizures. And that's consistent with a line of cases from the Court of Appeals as well. It's consistent with United States Supreme Court precedent that says, yes, we all carry this right around with us, but the way that we affect the right is to deny the government use of the evidence at trial. We don't affect that right by barring prosecution altogether.
Counsel on the other side make a very good point. The accusation itself of committing a felony has serious consequences on personal levels, professional levels, and forget conditions of release, which may be imposed or a detention hearing. I mean, it has consequences, very, very real consequences. I think of, and I analogize Peanuts, the character Pigpen, goes around with this cloud all over. That's a person under an indictment or under a criminal information. So that has very real consequences. It's not just something that's inconsequential.
And then what if the person is detained for trial? And they're sitting there because of illegally obtained evidence?
That's a very good question.
Because I don't think you're gonna argue that in a detention hearing, that the detention judge with a very low bar, preliminary decision-making, much like a preliminary hearing, can say, I'm excluding this evidence because it violates the Constitution either. So the error carries forward into the detention hearing. That person's detained, in some cases, for 4 years, pending trial. It's a pretty rough consequence.
I agree. And that's something that this court necessarily had to consider in Martinez when it found that, we're aware that the grand jury might hear illegal evidence and someone is going to be indicted as a result. And the real world consequences of being under indictment are very similar to being bound over for trial in a preliminary hearing. So it's not ideal. The state is not endorsing the use of illegal evidence at preliminary hearings.
know.
The state is very cognizant of how this can affect real people. But again, it's something the court necessarily had to think about in Martinez. And the court essentially put other interests, balanced the interests, and said, we don't like the idea that this will happen, but when we weigh it with other interests, we kind of have to say that the grand jury can hear illegal evidence and it's not going to invalidate the indictment. And there are other safeguards afterwards. A motion to suppress could be filed the day after a preliminary hearing and be heard within a couple of weeks.
It could.
Could.
There's a lot of asterisks next to that. It could.
Well, if they are going to be filed in the preliminary hearing stage, what's going to be the burden of the state? Do we have to add time under the rule? Another 30 days?
So
So
there,
the state can provide, because now you're in a discovery fight. Here we are at a preliminary hearing. We're trying to have preliminary hearings done quickly, especially for people incarcerated. Should we add 45 days for the incarcerated so the state can get the defense the evidence? And now we're going to have a full-blown suppression hearing at the preliminary hearing stage.
right, and the rules of criminal procedure, I can think of at least two off the top of my head that would have to be amended pretty significantly to allow this type of procedure that the defense is asking for to happen. Rule 5302 itself, obviously, the language would have to be changed to reflect that there is this right to raise a suppression issue. And as Your Honor mentioned, what's the timeline for that? Because in a lot of cases, the preliminary hearing has to happen within 10 days after arrest. So the timeline in a lot of cases is very short. And I do think that practically and realistically, if suppression issues are going to be meaningfully addressed, time would have to be added. And that means that somebody is potentially sitting in custody longer so that the suppression motion can be raised at the preliminary hearing. Rule 5212 as well, which governs motions, at least in the district courts in general. That rule states that when you file a motion to suppress, it has to be written and the opposing party has to have 15 days to respond. So again, logistically, if we're holding preliminary hearings 10 days after arrest and the state has a right to 15 days to respond to a motion to suppress it, it just doesn't line up.
But
So
isn't that concern mollified by the fact that the state gets multiple bites at the apple after this decision? It's not binding. You can get your ducks in a row, ask for another prelim, you can go to grand jury. There's all kinds of things that then would buy the state more time if in fact there's something to shore up. But in cases where there's nothing to shore up, this keeps that person from going through this process, potentially being detained and waiting a very long time for even a suppression hearing to occur. I can imagine if we had the tools to do this, which we don't, if we had the tools to survey how long it takes judges to get to suppression hearings, you would find great variety in how long that takes. And that person's being detained the entire time we're waiting for that to happen, where you have something that is obvious and the state really can't contest.
It's true that the state can go to grand jury if someone's not bound over to preliminary hearing, but all of those avenues just kind of lead to multiplying proceedings unnecessarily. That's the state's position.
But if this cleans up the case and the state says, you know, we've done this soul searching, to use Ms. Smith's words, and we're not going to pursue this, doesn't that create efficiency?
Not to a degree that is larger than what the opposite would create.
And
That's the
does
state's position.
efficiency trump the Constitution?
I would not say it trumps the Constitution, but it is of significant consideration. And this court put a lot of weight on it in Martinez. So balancing the Constitution and efficient dockets and efficient court functioning, it is something we have to look at. If we allow suppression motions to be heard at preliminary hearings, but those rulings aren't binding, and then they're not binding on the rest of the proceedings, and we have another motion to suppress 3 months later, it's just any way we slice what the defense is asking for creates a multiplicity of proceedings. If judges are, and this case highlights how easy it is for a judge to make an uninformed suppression ruling on the fly because the state was given no warning that the motion was coming. The motion was raised orally after the officer testified. The state had no opportunity to maybe do a little bit of legal research and find the case law that very clearly says when an officer knows of an arrest warrant, that's valid cause to stop somebody. So this case highlights that if we're allowing these motions to just be raised very quickly, now here we are 2 years and 2 appellate courts later litigating the issue because this motion was raised in the way that it was, prematurely at a preliminary hearing.
What if there were slightly different facts in this case, and the court, rather than doing a written order that included the suppression language, just says there's no probable cause? I mean, that's what we're inviting. It's just no probable cause, and we'll never know the basis for that. Because if a judge thinks the evidence is that stinky, and I don't think that comes up with regularly. You have one really key fact that kind of then governs the rest of the case. They're just going to sit in silence and say no probable cause.
That's correct.
And that's what we're inviting here. Or we're inviting, you are bound by this no matter what it is. And that's taking away any semblance of judicial discretion, which is the je ne sais quoi of a trial court judge.
There could be some kind of safety valve built in. A judge, if they are that concerned with the illegality of evidence, just based on what they've heard in the preliminary hearing, could instruct the parties to brief the issue, set a hearing in 2 to 3 weeks. I understand the court's concern, I do, and it's a tricky issue, but it kind of all comes back to the exclusionary rule, both federally and in this state, is treated as something that kicks in at trial. This court has said that a couple times. The United States Supreme Court has said that, and I'd like to quote from United States versus Blue because I think this language is very informative. The Supreme Court said the barring of prosecution where unlawful evidence is presented in a probable cause hearing might advance marginally some of the ends but to be served by the exclusionary rules, but it would also increase to an intolerable degree interference with the public interest in having the guilty brought to book. The appropriate remedy is ordering the illegally obtained evidence suppressed at trial rather than barring prosecution altogether. And so that's the state's position, is it's a weighing of interests. It's determining the right time for the exclusionary rule to kick in. And the state maintains that this is not going to, if this court upholds the Court of Appeals ruling, it's not going to invite in any way prosecutors to knowingly use illegal evidence. Prosecutors are always expected to exercise their charging discretion in good faith. There's also not a lot of incentive for prosecutors to bring cases where when they're screening it, they see this isn't going to go anywhere. Prosecutors are stretched very thin as it is in New Mexico. And I know that at least in Judge Lovelace's district, there's an entire unit of prosecutors at the district attorney's office whose entire function is to take these cases as they're coming in from law enforcement and look very, very closely to see, is this something that we can even take to grand jury or to a prelim yet? Or do we need more information? Or is this a total loser and we should just not take it? So
Let's take the scenario of the reverse, where we have these concerns expressed. But let's take the concern of a defendant in which, at the preliminary hearing stage, the judge says it was constitutional on these very limited facts, undeveloped, but says it's constitutional. This is good. This is a good stop. Good stop, good search, got the drugs. When they, not to point to my colleague, but when they go down the hall, I don't know how that judge is not bound by that decision. And my second question is, what is the standard of review after that? Does that defendant have a chance then at the trial court to say, I want to challenge that same stop constitutional?
and I think
And that seems to me a problem with the procedure they're suggesting. It's short shrift to a question that most often has intricate factual questions involved.
I agree, and in many cases, all of the facts that are needed don't come out, let's say 10 days after a person is arrested. I think the defense's position was that all of these kinds of decisions would be reviewable again at some point in the proceedings and not binding from the preliminary judge onto the trial judge. Again, that's just creating a multiplicity of proceedings. It is unnecessary.
But do you disagree with Ms. Smith's assertion that that preliminary decision is not binding on the trial court? I mean, I think Justice Thompson's almost asking you a res judicata question. Is it res judicata if a decision of any decision made at a preliminary hearing? And I think our answer has to be no, because the evidence may prove in the end that there was, in the end, there's probable cause.
Or it may not.
I tend to agree with Your Honor. I think the answer has to be no, and I'm basing that on case law that says preliminary hearing judges and trial judges are operating in two totally different functions. It's like they're two different courts. I think there's actually, I don't know if it's.
We have to have that rule or the
Right.
system wouldn't work.
So
One is very expedient and one you have more time.
And one is
Exactly.
not binding on the other.
So it would not be binding. It would be able to be raised later on down the line. And I think that cuts against both sides. That leads to defendants, proceeding in cases where they thought they had their evidence suppressed and then it gets into trial. And same thing for the state. The results would be confusing. I think it would lead to a lot more appeals going up to the Court of Appeals because of kind of inconsistent rulings in one case. And so I agree. I think it would not be binding on the trial court, the decision made on legality of evidence at the preliminary hearing.
Well, hypothetically speaking, if a preliminary hearing happens and a trial judge makes a suppression decision, suppresses some evidence, there is still evidence for the state to proceed with, and the court binds over for trial some charges, maybe even all charges, but there's still that looming decision regarding this evidence that you may want to get in. What do you appeal? Do you appeal that decision? Do you file a motion to reconsider with the trial judge and see if you can get that judge to convince that judge that no, it's not illegal? How do you realistically and practically proceed as a prosecutor?
That's a great question. I think if it results in dismissal of charges, the proper course for the prosecution would be an appeal. But I know that whether the prosecution has a right to appeal in that situation was before this court yesterday, so that's yet to be decided. I think it could go either way, depending on how this court writes its opinion. And review, I guess I'm kind of grappling with the fact that it would result in dismissal of certain charges rather than just suppression of evidence. I think if charges are dismissed, the prosecution could always take those to the grand jury, and then the suppression issue in the original case would have to be relitigated by the trial judge.
Could you have a conditional agreement that there's probable cause conditioned on your right to appeal the suppression order?
Could you repeat the question, please?
Okay, think conditional plea, but now we're doing a conditional waiver of the bind over, condition on you appealing the suppression order or lack of the refusal to suppress.
I think that could be an option, yes. So again, I think what it really all comes down to in this case is looking at the exclusionary rule and how it's best affected in New Mexico. And this court has been pretty clear that even when illegally obtained evidence is introduced at a probable cause hearing, yes, it's not ideal, we don't like it, but the proper remedy is not to disturb the indictment or the probable cause finding. The proper remedy and the way that we allow individuals to carry out their right under Article 2, Section 10, or the Fourth Amendment, is to suppress the evidence at trial. So just based on the case law alone and a very close reading of it, the exclusionary rule does not kick in at the preliminary hearing stage. And under Martinez, we know that both grand jury and preliminary hearings, their purpose is very, very limited. All the state has to show is there probable cause to believe an offense was committed and probable cause to believe this person committed it. So the screening function of the preliminary hearing is not to test whether the state's evidence would be competent at trial and whether the state could prove its case at trial. It's just to say, can we allow the state to move forward? And so the screening function would not be undercut by essentially holding off on suppression issues until sometime after the preliminary hearing. Because again, the state's position is that the number of cases that would show up in front of a preliminary hearing judge based wholly on totally incompetent illegal evidence would be very low. And there is always the option to file a motion to suppress after the preliminary hearing. So the screening function, it's the state's opinion that it would not be undercut, it would not be significantly affected, it would still be.
Can I stop you? I'm sorry.
Yes, of course.
How can you say that the number of cases that would fall into this scenario will be very, very small, yet argue that the arguments on appeal will be very, very big? Either there's a ton of these cases and there will be a ton of appeals, or there'll be very few cases and very few appeals.
So I think what I was saying about appeals is that would happen if we allow these suppression issues at preliminary hearings. That would create more appeals because then we have a ruling at the prelim and then that's reviewable by the trial judge later down the line. We've got inconsistent rulings. And now
One is not binding on the other. One is preliminary. It'll be the trial court judge's decision that's appealable. It's not going to be the contradiction between the preliminary hearing judge and what the trial court judge decides.
No, it wouldn't be the contradiction.
So it's not, you're saying, well, but because there's going to be these contradicting points of view, the appeals are going to go through the roof. But if this is going to happen in really limited scenarios, we're not going to have appeals going through the roof.
So I think what I was trying to say is the appeal wouldn't stem from the contradiction, but I think if the state, I'm just thinking as a prosecutor, if the state is proceeding under the impression that they have this evidence to work with or they don't, and then that kind of 2 months, 3 months later goes out the window, that's why I think there could be more appeals. So that's what I was saying, not that the state would appeal the inconsistency between the preliminary judge's ruling and the trial judge's ruling, just that having that uncertainty.
Well, except you just said the prosecutor thinks they've got these 5 pieces of evidence. and then later there's going to be a decision removing some of that, that's called a suppression hearing. It happens all of the time.
Right.
So knowing at the front end, I've got real questions about this evidence, allows them to better prepare for either getting it in or knowing the boundaries of the evidence they have going forward. I think it's actually the inverse of what you've just argued.
So maybe it wouldn't lead to more appeals, but allowing preliminary hearing judges to make suppression rulings, I think would lead to more appeals. That's why we're here. So one of the things that the defense talked about in their brief was the fact that preliminary hearing judges are already expected to make evidentiary rulings, and therefore they should be allowed to make suppression rulings. That's, of course, true. The rules of evidence apply at a preliminary hearing, and the judge is expected to rule on hearsay objections and things like that. The difference is that's all happening in real time in the courtroom. Those objections are very easy to rule on. All the information that the judge needs is before them in that moment. Suppression is a little different. It requires, motion practice. It requires research. It could require calling additional witnesses in some cases. That's another thing that could lead to additional proceedings. There would be some cases where the state only has to call one witness to prove probable cause for a bind over, but would have to call 2 or maybe even 3 witnesses to address a suppression issue. And the example that I think of in that case is a DWI checkpoint, because if you're just trying to establish probable cause, you can just call the officer who, the defendant drove up and the officer saw him and he was intoxicated. But if we're going to bring suppression into it, then we have to hold a full Betancourt hearing on whether the checkpoint itself was reasonable. And so this just all goes to say that allowing suppression motions at preliminary hearings would cut directly against what this court was really concerned about in Martinez, which is creating mini trials, kind of clogging up the dockets. And it would encourage prosecutors to favor one over the other. And that's kind of problematic. I think the preliminary hearing was kind of invented in the first place to take a lot of the strain off of the grand jury, because the grand jury was the only way, and there were just too many cases.
Let me ask you this.
Yes.
So, and it was alluded to in the petitioner's brief in chief that the Court of Appeals decision wasn't a shall, it was a may. In other words, that the trial judge may review the evidence and make a determination regarding whether it's unlawful or not. So is there not room for a trial judge saying, it hurts my brain, it's too complicated, I can't deal with it in this neat 30-minute block of time I've allotted for this, you'll have to take it up with the trial judge? Isn't that a possibility?
I think it is. And there's also the possibility that I mentioned before where the judge could just say, brief the issue and come back in 2 to 3 weeks.
Although the new rule requires a disposition be entered within the time frame.
That's true. I did read that amendment recently. I agree with you. So I guess that's not as viable of an option as I assumed. So just to conclude, the exclusionary rule in New Mexico, it's very clear under the law. It does not kick in at the preliminary hearing stage. The purpose of the preliminary hearing is very limited. The screening function is just to figure out whether the state can proceed with charges. There are ample opportunities to raise suppression issues after the preliminary hearing. Nothing in Rule 5302 contemplates suppression issues at a preliminary hearing, and all of the practical considerations cut against allowing that practice. So the state would ask this court to affirm the Court of Appeals. Thank you.
I want to start right where Judge Lovelace left off. That's the rule we're asking for. We're asking for a rule that if there is a violation apparent to the court.
But not a rule. You're asking for an opinion from this court that essentially says that a judge who is taken an oath to uphold the Constitution of the state of New Mexico essentially has to review the decision or has to review the lawfulness of the evidence. I mean, essentially there is no may or it's all or nothing. So if anyone comes in front of in a preliminary hearing in front of a trial judge and says this evidence is unlawful, that judge automatically shall review it to determine its lawfulness, assuming you're successful.
I don't know that that's true, Your Honor. And I don't know that would be a bad rule. But I think to the extent we are concerned about what's happening at preliminary hearing, and of course, suppression hearings can happen later, I don't see any problem with a rule that says, with an opinion from this court that says, we don't want district courts, or we don't want preliminary hearing judges, whether they're from the district court or elsewhere, to be complicit in a constitutional violation. We don't want them to be forced to bind over a case based solely on evidence that was illegally seized. But we also don't want them, if there's a case where they have to bring in a whole other group of witnesses, where they have to go really beyond the scope of what they were already hearing, we don't want to overburden the preliminary hearing. I think there's room for a rule that says, if there is a violation that is apparent to the judge has the authority to rule on it. And the Court of Appeals rule is the judge lacks the authority. It doesn't matter how crystal clear the violation is. You know, in this case, it's a 20-minute hearing. Nobody else has to come in. A lot of times for Fourth Amendment issues, it'll just be one officer, and that's the officer who they were going to call at the
Ms.
suppression
Smith?
hearing.
I'm contemplating in my mind, and correct me if I'm wrong, that a preliminary hearing judge could do a bind over, and if counsel thinks that that's based in part or in whole on illegal evidence or unconstitutionally obtained evidence, file a motion to set aside the information on that basis before the trial judge is assigned to the case and get an expedited hearing on that. Would that not be sufficient to vindicate the interests at issue? And then you're not running into inconsistent results, delaying the grand jury, doing all this, but you have a mechanism in place to vindicate that right at the preliminary hearing, which says nothing about whether or not evidence would be admissible at trial.
I think, Your Honor, I think that's overcomplicating it. I think all that needs to happen is the judge who, in New Mexico, if you're presiding over a preliminary hearing, you're a judge who does suppression hearings too. You know what some of these fact patterns look like. All that needs to happen is this court say, no, you are allowed, you may judge at the preliminary hearing, as you judge all sorts of other things at the preliminary hearing. You may judge that this evidence was illegally seized and therefore it doesn't form part of your determination. I think the others, I don't
I
mind it,
understand.
but it's complicated. This is what we do already. So with evidentiary motions, a lawyer might not be allowed to ask a question at preliminary hearing, but would be allowed to ask it later at trial on cross-exam.
But you don't do it 15 days from arrest.
No, and a lot of times there won't even be a
or
motion to
45 days.
suppress. There won't even be a Fourth Amendment motion at preliminary hearing because the defense won't be aware of it yet. It'll be in a situation like this where it comes up organically or where there is some reason to believe that there's a problem.
I'm still not clear on the process. So we're going to have a motion to suppress at the preliminary hearing. There has to be some kind of process. You can say, there's got to be a process. As soon as that motion to suppress comes in, there's got to be, if there's going to be a determination on the facts, discovery. I just don't see how you build this in.
Well, not necessarily, because what I think what we're thinking of when we say motion to suppress, which is why I've largely avoided that language,
Okay.
is
Well,
the Rule 5-12 hearing. But the Rule 5-12 is about remedies. Rule 5-12 is this is what you do if you want return of illegally seized evidence or if you want evidence excluded at trial. If you
And
want
that's where
trial
the
suppression.
exclusionary rule attaches.
That's where that version of it attaches, Your Honor. So everything we're used to about time to respond and the hearing and all of that, that is that hearing. But there's no reason why a judge presiding over a flexible, informal preliminary examination can't hear something, can't hear an officer testify. Well, what I saw was there was a guy standing on a street corner with a sign that said, "I hate cops." So I went over and I searched him. There's no reason a judge can't say, was there any other reason? And the officer says no. We don't want the judge to be forced to bind over, and there's no additional process needed. Again, if the judge makes a mistake, there are other things, but I do want to point out, this is the rule we have already for other things. This is the rule we have for evidentiary rulings, and frankly, this is the rule we have for the Fifth Amendment. If there is this 10th Circuit case vote, which says the Fifth Amendment attaches at probable cause hearings, at a prelim, which means a judge in New Mexico conducting a prelim has to consider that, or it has to consider an apparent.
They would have to do it anyway because it's a rule of evidence. So they have to make evidentiary determinations. 11-1101 says that with the exception of privilege, the New Mexico rules of evidence apply at all proceedings except the litany, or the list. So privilege applies in any proceeding.
But this isn't privilege. This is the Fifth Amendment exclusionary rule.
Well, it's based on a privilege.
Could be based on a failure to Mirandize.
Or it's a privilege, the Fifth Amendment privilege.
I wouldn't. It's also a constitutional right, Your Honor. I would raise all of the same considerations as Fourth Amendment. I would also just say, I have 15 seconds. I would also just say, the state has repeatedly said there is case law in New Mexico saying the exclusionary rule doesn't kick in at a preliminary hearing, and I don't think that's the case reviewing the cases here, so I would just say that to the court. We appreciate the court's time. Is there no further questions?
All right, counsel, thank you everyone for your arguments. They were illuminating today, and I'm going to give extra props to Ms. Francolini because she's done double duty this week in front of us, and we weren't any kinder or less inquisitive in her other hearing. So thank you for that. This case is deemed submitted, and we'll get you a decision as soon as we can. Thank you.
Down the court.